As stated in the landmark case of Brown v. Board of Education, today education is perhaps the most important function of state and local governments. According to former Chief Justice Earl Warren, compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. And accordingly, at least according to the rules stated by the Supreme Court in that case, such an opportunity where the state has undertaken to provide it is a right, a civil right, which must be made available to all on equal terms. And yet, on March 13, 2020, at a time when there were less than 45 reported cases of COVID-19 infection in the entire Commonwealth of Virginia, and only 5 reported cases in the county of Arlington, with not even yet one fatality reported in the entire state, and even before any order had been issued by the former Virginia Governor Ralph Northam, a medical doctor, the Arlington Public Schools made the executive decision, to begin to suspend in-person instruction, what had amounted to a total of almost 30,000 school-aged children in public schools, certainly in an infringement to what has been recognized by the nation's highest court as their civil rights. The Supreme Court has held that a suit does not present a case or controversy unless the plaintiff establishes that he has suffered an injury in fact that is fairly traceable to the defendant's conduct and that is likely to be redressed by a favorable decision. And certainly, at least by September of 2022, it had been known that students in the public schools of Virginia had, in fact, suffered losses in reading and mathematics aptitude, placing Virginia ranked 6th in the nation for such losses. And the United States Supreme Court has consistently rejected the plaintiff's standing to bring a lawsuit against any generalized grievances that were being attributed to governmental misconduct that does not impact the plaintiff in some unique way. And it is a fact that very early, many pundits were stating after schools had been closed that there would be reasonably foreseeable losses that would be experienced by these students because of the closing of schools to in-person instruction. And at that time, however, when the public schools had been closed in the county of Arlington, many students went online to express their opposition and objections to canceled graduation ceremonies and proms, the concerns of children, creating petitions to announce their grievances. But at least under the law, specifically under VA Code 22.1-87, any parent, custodian, or legal guardian of a pupil attending the public schools in the school division who is aggrieved by an action of the school board may, within 30 days of such action, petition the circuit court having jurisdiction in the school division to review the action of the school board. And under that rule of law, the action of the school board shall be sustained unless the school board exceeded its authority, acted arbitrarily or capriciously, or abused its discretion. The statute of limitations told on court review of that action 30 days after the closing of public schools, where any person, parent, guardian, custodian, withstanding under the application of the law was granted the fair opportunity to speak, then or forever hold their peace. And of record, none came forward. The doors were open and the invitation was offered, but none came. And so, albeit in silence, the people had spoken. And today, at least for purposes of that civil action, that issue is considered mooted law. Yet still many persons continue, certainly in online and alternative forums, to express their grave objections to the closing of public schools, even providing quite a spirited discussion, at least in the spring of 2021, during the Arlington Democrats Party caucus for the selection of candidates for the Arlington Public School Board, but avoiding the essential question for any judicial review whether or not the school board had, in fact, exceeded its authority, acted arbitrarily or capriciously, or had abused its discretion. Akin to those who had, at least according to the popular press, voiced their allegations of election fraud and stolen elections, but failing to present any credible evidence to corroborate what amounted to only what might fairly be described in the courtroom as frivolous and vexatious claims. There is a peculiar thing about making a legal argument, especially in court, that for some inscrutable reason, to some, they quite often require you to actually make a legal argument, cogently stated. So for the next few moments, thinking like a lawyer and using this legal formula, we shall examine the question as to whether the Arlington Public School Board had in fact exceeded its authority, acted arbitrarily or capriciously, or abused its discretion, which is now the topic of a case underway in the federal courts. Many laymen in political commentary may speak of conspiracy theories, but it's a legal term of law. Under Virginia law, the elements of common law conspiracy are: 1, an agreement between 2 or more persons; 2, to accomplish an unlawful purpose or to accomplish a lawful purpose by unlawful means, which 3, results in damage to plaintiffs through an overt action done pursuant to that agreement. Have you or anyone you know been injured by an action by the Arlington Public School Board? Simply stated, when one speaks of a conspiracy for purpose of legal action, there are at least 2 persons involved, and at least 1 unlawful transaction and conduct or illegitimate purpose that had been set in motion. Some persons have claimed to have been aggrieved, but at least the law would require a little bit more. Many persons in political commentary may speak of duty, but at least in the law regarding tortious conduct, everyone owes to the world at large the duty of refraining from those acts that may unreasonably threaten the safety of others. And generally speaking, every potential plaintiff who might bring a matter in a court for judicial review is entitled to have the defendant exercise the highest degree of care required. Negligence may be defined roughly as an act or omission which unreasonably does or may affect the rights of others, or which unreasonably fails to protect oneself from the dangers resulting from such acts. And there must be both the act or the omission and the right, for it is the act itself, not the intent of the actor, that is important. And accordingly, if a person brings or accumulates on his land anything which, if it should escape, may cause damage to his neighbor, he does so at his peril. If it does escape and cause damage, he is responsible, however careful he may have been, and whatever precautions he may have taken to prevent that damage. If a civil action were to be commenced, judicial review of agency action is limited to the grounds that the agency invoked when it took the action, importing this requirement for establishing whether, in fact, upon the evidence, the school board had exceeded its authority, acted arbitrarily or capriciously, or abused its discretion. At a minimum, under civil law, if those grounds are inadequate, a court may remand for the agency to offer a full explanation of that agency's reasoning at the time of the agency action. And yet, of record, while there has been much spirited discussion connected to the closing of public schools, none within 30 days before the statute of limitations or after had presented that case to any form of legal effect. This message was approved by Major Mike Webb. Honest.